Hello dear viewers, dear students, welcome back to video class. How are you dears? Okay, last class we discussed section 300 of the IPC. Okay, same subject also today also discussing 300 subclass 3. Okay, 300 subclass 3, murder. Subclass 3 is explain about with the intention of causing bodily injury to any person sufficient in the ordinary course of nature to cause death. Okay, section 300 subclass 3 clearly indicated. Okay, so in this situation the class explained the distinction between this class and section 299 subclass 2. Okay, depends upon the degree of probability of death from the act committed. If from the intentional act of injury committed, the probability of death resulting is high. The finding will be that the accused intended to cause death or injury sufficient in the ordinary course of nature to cause death. If there was probability in a less degree of death ensuing from the act committed, the finding will be that the accused intended to cause injury likely to cause death. So here, where a man intentionally kills another or intentionally inflicts bodily injury sufficient in the ordinary course of nature to cause death, his act is murder. Okay, now let's understand what is the meaning of murder. But here the accused dealt several blows with a fairly heavy lathi. This is one example. Blows with a fairly heavy lathi on the body of the deceased, causing fracture of two ribs. Human body, human ribs. So what will happen? It will pain and injury also. Two ribs automatically, you will not move properly, automatically respiratory infection also coming out. Okay, in this situation, injury to the pleura and laceration and puncture of the right lung. Okay, it was held that the accused was guilty of murder. So this is what saying section 300. Okay, but in the case of another case, in the case of Mangesh versus state of Maharashtra, Mangesh versus state of Maharashtra, Supreme Court stated the circumstance from which it may be gathered as to whether there was intention to cause death. It included circumstances like nature of the weapon, on what part of the body the blow was given, the amount of force, was it a result of a sudden fight or quarrel. Okay, note that point. Whether the incident occurred by chance or was premeditated. Okay, with premeditated, prior animosity, grave and sudden provocation, heat of passion, did the accused take any undue advantage? Did he act cruelly? Number of blows given, or etc. Okay. So even if none of the injuries by itself was sufficient in the ordinary course of nature to cause death, cumulatively such injuries may be sufficient in the ordinary course of nature of to cause death. Here, where an injury is intentionally inflicted, the defense that no proper medical treatment was forthcoming does not exonerate the person who caused the injury from guilt of murder if he intended that the injury should be sufficient in the ordinary course of nature to cause death, or knew that it was likely to cause death to that person. He does not exonerate him from guilt of culpable homicide if death ensues as a natural or likely consequence. Such a person is deemed to have caused the death, and his degree of criminal responsibility must depend on the knowledge or intention to be gathered from the proved facts. Okay. And another thing, if the injury caused directly and deep into the stomach of deceased, a very vital part which had led to the death within a short time, it is argued that said injury caused to deceased would not fall under section 3 under subclause 3. Okay. And so such conviction recorded under section 304 part 1 or part 2 of Indian Penal Code, it cannot be said that there was no intention to cause that very injury which had led ultimately to the death of the deceased. Okay. Here, and another part where doctor had clearly established that the injuries sustained by the deceased were all simple in nature, inflicted upon non-vital parts of the body, intention or knowledge cannot be attributed to the accused. This is what saying. And another point, section 3 under subclause 3, saying that by altering the conviction for section 300 entered by the trial court, the High Court opinion based on the injuries, that is caused on right and left cheeks of deceased by sharp edged weapons, and injury number 4 based on this example, which was an incised wound on the occipital region of the skull without cutting the bone, that the offence was one under section 304 of IPC. Nevertheless, the Supreme Court held that the fact that the accused hurled hurled country made bombs has been established. The incised injuries caused to the deceased were intentional and were sufficient to cause death in the ordinary course of nature, even if it cannot be said that his death was intended. This is sufficient to bring the case within section 300 subclause 3, right? And another point of view, if any bodily injury The expression bodily injury in section 3 under subclause 3 includes also plural, so that the class would cover a case where all the injuries intentionally caused by the accused are cumulatively sufficient to cause the death in the ordinary course of nature, even if none of those injuries individually measures up to such sufficiency. The sufficiency spoken of in this class, as already noticed, is the high probability of death in the ordinary course of nature, and if such sufficiency exists and death is caused and the injury causing it is intentional, the case would fall under 3 under subclause 3 only. So all the conditions which are prerequisite for the applicability of this class have been established under the offense committed by the accused. In the instant case was murder. Now it's clear, this above sentence. Okay. And then what is required for the prosecution to prove to bring the case under class 3 under subclause 3? Number 1, it must be established quite objectively that a bodily injury is present. Secondly, the nature of the injury must be proved, and these are purely objective investigation. Thirdly, it must be proved that there was an intention to inflict that particular bodily injury, that is to say that it was not accidental or unintentional, or that some other kind of injury was intended. And once these three elements are proved to be present, the inquiry proceeds further. Okay. And fourthly, it must be proved that the injury of the type just described, made up of the three elements set out above, sufficient to cause death in the ordinary course of nature. This part of the inquiry is purely objective and inferential and has nothing to do with the intention of the offender. Once these four elements are established by the prosecution, that is, and of course the burden is on the prosecution throughout. The offender is murder under section 300. Okay. Thirdly, it does not matter that there was no intention to cause death. It does not matter that there was no intention even to cause an injury of a kind that is sufficient to cause death in the ordinary course of nature. It does not even matter that there is no knowledge that an act of that kind will be likely to cause death. Once the intention to cause the bodily injury actually find to be present is proved, the rest of the inquiry is purely objective, and the only question is whether a matter of purely objective inference, the injury is sufficient in the ordinary course of nature to cause death. No one has a license to run around inflicting injuries that are sufficient to cause death in the ordinary course of nature and claim that they are not guilty of murder. If they inflict injuries of that kind, they must face the consequences, and they can only escape if it can be shown or reasonably deduced that the injury was accidental or otherwise unintentional. On this particular point, there is the following pertinent observation of the Supreme Court. The nature of the offence does not depend merely on the location of the injury caused by the accused. The intention of the person causing the injury has to be gathered from the careful examination of the facts and circumstances of each as per the given cases. The present is not the case where the appellant merely swung his knife towards the leg of the deceased during some struggle and it happened by sheer misfortune to cut an artery that the appellant had intended to cause injury to the vital parts of the deceased is clear from the fact that he administered a stab wound on the chest of the deceased on the backside. It is also significant that the knife blow dealt by the appellant in the groin, groin of the deceased had caused a wound 8 cm deep, piercing both the femoral blood vessels. Moreover, when the brother of the deceased tried to intervene, the appellant inflicted 2 stabs wounds on him, which were of identical pattern. Taking into account all the circumstances, we have no hesitation to agree with the courts below that the appellant was clearly guilty of the offence charged against him. So thus, the intention to cause the request type of injury is absolutely necessary. The Supreme Court found on the facts of the case that there was an intention to cause an injury, and with that intention a single knife blow was administered. The blow fell upon the left shoulder, cutting a wound through it and tearing up vital arteries which came in the path of the knife. The injury was sufficient in the ordinary course of nature to cause death, but there was no intention either to cause death or cause the type of injury as actually resulted. The conviction of the accused was accordingly shifted from this section to that is under section 304 of the Indian Penal Code. And again, the Supreme Court also observed that the intention to cause the request type of injury is a subjective injury, but that once the type of intention is found in the assailant, the further inquiry whether the injury was sufficient in the ordinary course of nature to cause death is of objective nature. On the facts, the court held that on an exchange of hot words, a single kirpan blow on chest which punctured heart and caused instantaneous death was sufficient to establish the subjective intention to cause death. This is for section 3 under subclass 3 explained, and clear example also I given. Then another thing, I just wanted to elaborate this section also. The principle of exclusion. In this class, some principle is available. So recently in Rampal Singh with state of Uttar Pradesh, this very good case for referring to the pronouncements in Rayavarupa Punnaya, Vinit Kumar Chauhan versus state of Uttar Pradesh. These are all evidentiary case, and the Supreme Court opinion thus, the evidence lead by the parties with reference to all these circumstances greatly helps the court in coming to find conclusion as to under which penal provision of the code the accused is liable to be punished. This can also be decided from another point of view, that is by applying the principle of exclusion. Okay, based on the above cases, the Supreme Court gave some principle, that means principle of exclusion. The principle could be applied while taking recourse to a two-stage process of determination. Number one, first, the court may record a preliminary finding if the accused had committed an offence punishable under the substantive provision of under section 302 of Indian Penal Code, that is culpable homicide amounting to murder. Then second one, it may proceed to examine if the case fell in any of the exceptions detailed in section 300 of the Indian Penal Code. This would doubly ensure that the conclusion arrived at by the court is correct on the facts and sustainable in law. We are stating such a proposition to indicate that such a determination would better serve the ends of criminal justice delivery. Here, the section 300 subclause 3 views the matter from a general standpoint. Here, the emphasis on the sufficiency of the injury in the ordinary course of nature to cause death. The sufficiency is high probability of death in the ordinary way of nature. When the sufficiency exceeds and death follows, and causing of such injury is intended, the offence is murder. Sometimes the nature of the weapon used, sometimes the part of the body on which the injury is caused, and sometimes both are relevant. In some cases, the sufficiency of injury to cause death in the ordinary course of nature must be proved and cannot be inferred from the fact that death has in the fact taken place. In such a case, it may not be open to argue backwards from the death to the blow to hold that the sufficiency is established because death did result. A death can take place from other cause. The sufficiency is required to be proved by other and separate evidence. Okay. So there was an example, there was assault on a woman by 3 persons. The eyewitness account was on the main accused gave a lathi blow on the head of the deceased and she fell down. The medical evidence showed that the injury was on the top of the head and that injury was sufficient in the ordinary course of nature to cause death. The main accused alone was convicted for the act of murder. The remaining 2 were given the benefit of doubt. Medical evidence proved by the prosecution also does not suitability support the prosecution story. Accused acquitted. Now it's clear this principle of exclusion, and the Supreme Court has observed that there is no such thing as a regular or earmarked weapon for committing murder. The accused in this case was carpenter. About the implements, the court said that they could not be described as deadly weapons. Of the 2 injuries inflicted by the carpenter, one was found to be serious. There was absence of motive and also lack of knowledge that death was results from the injury. his conviction was altered from section 302 under section 304 of Indian Penal Code. Now it's clear this point. And another thing I just wanted to focus in this section, the contradiction between ocular and medical evidence. How it will be happen? Where there is a contradiction between medical evidence and ocular evidence, the position of law can be crystallized to the effect that though the ocular testimony of a witness has greater evidentiary value vis-a-vis medical evidence, when medical evidence makes the ocular testimony improbable, that becomes a relevant factor in the process of the evaluation of evidence. However, where the medical evidence goes so far that it completely rules out all possibility of the ocular evidence being true, the ocular evidence may be disbelieved, the opinion given by medical witness need not be the last word on the subject. Such is not obliged to go by that opinion. After all, opinion is what is formed in the mind of a person regarding a fact situation. If one doctor forms one opinion and another doctor forms a different opinion on the same facts, it is open to the judge to adopt the view which is more objective or probable. Similarly, if the opinion given by one doctor is not consistent with probability, the court has no liability to go by that opinion merely because it is said by the doctor. Of course, due weight must be given to opinions given by persons who are experts in the particular subject. Where the testimony of eyewitness totally inconsistent with medical evidence and suffering from improvements, the rule that ocular evidence has precedence over medical evidence cannot be applied. Okay, and when the doctor in his examination in chief examination had categorically stated that the incident could have occurred at 8 a.m., which corroborated the case of the informant, there was no reason to disbelieve this fact, to hold that the incident occurred between 2 and 4 a.m. Here, an opinion given by a doctor based on the facts recorded on an examination of a victim of a crime could be rejected by relying on cogent and trustworthy eyewitness testimony. What is happening here? This ocular and medical eyewitness. As to the opinion of the doctor, it is opinion by the Supreme Court, leading case Ram Kumar versus State of Madhya Pradesh. That case, considering the injuries and fractures sustained by the victim, which are dangerous as to cause death of a person, it is not necessary for the doctor to give a specific report to the effect that injuries were sufficient in ordinary course of cause death. So death due to constriction force around the neck leading to asphyxia. This is medical terminology. Asphyxia, 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 and shock, as observed by the doctor, which is possible not necessarily by hanging. Although the doctor has opinion, it could be caused probably by hanging also. Yet the signs of hanging, as reported in a famous book, Modi Jurisprudence and Toxicology, were absent. So conviction under section 302 of the Indian Penal Code held proper. Okay, and another point I just wanted to give, the discrepancy between the reports of the doctor who examined the deceased and the doctor who conducted autopsy, AUTOPSY, autopsy. Insofar as fatal injuries are concerned, and for this there is no discrepancy between the two reports. Court verified both the reports and satisfied that the said discrepancy is not material to the prosecution case, where the medical certificate showing age of the injuries as 24 hours, but in post-mortem report it is mentioned 6 hours. So it was held that in post-mortem report the determination of the precise duration of the injuries can be possible due to the internal examination of the injuries, whereas no such advantage is available to the doctor when examines the injuries in the nature of contusions, CONTUSIONS, contusions. So plea of inconsistency in medical report and post-mortem report also. And finally, the construing medical opinion, the doctor stated that the cause of death was incised cut wound on the neck with lead to excessive bleeding and heart failure. The Supreme Court said that the High Court observation that the doctor did not state that the injury caused would in the ordinary course be sufficient to cause death was contrary to the manner in which medical evidence is to be construed. Okay. And finally, another report, FSL report. Merely because the FSL report was inconclusive, okay, it is not necessary that irresistible conclusion is only one that the accused is not guilty, particularly where the prosecution has been able to establish its case on circumstantial evidence as also by direct oral evidence. The fact that FSL reports does not clearly state or link appellants with the commission of the crime is of no consequence in the facts and the circumstances of the case. Failure of investigation officer to send the blood stained gunny bags and weapon of the offense to the forensic department, forensic science laboratory, that means FSL. Okay, FSL means forensic science laboratory, is not fatal to the case of the prosecution. Okay, failure of the investigation officer in sending the blood sustained, the failure of the investigation officer in sending the blood stained cloths to the FSL. The main stained cloth is very important in the forensic department. So these are all the physical evidence. So then only they will check. An empty cartridge to the ballistic expert would not be sufficient to reject the version given by the eyewitness. Okay. The fact that deceased had a few strands of hair in his hand which did not match with any of the accused except accused 13, A13. A1 accused, A2 accused, something like, no. In this case, A13 accused, who was already acquitted by the trial court as well as the high court, does not hold much ground as it by itself cannot exonerate the accused only because the samples do not match. So where only one knife out of the 4 knives alleged to have used we sent for forensic examination and the blood found therein was disintegrated, the contention that only one knife was used did not stand as multiple knife injuries found on the deceased. Okay. And injury caused should be evidential cause of death. Finally, the prosecution has to beyond reasonable doubt that eventual cause of death was injury caused by the accused. The accused in this case inflicted a single blow on the head of his victim with a canta. The victim survived for 38 days. The court that there was absence of intention kill because there was no further assault. There was report on case sheet showing the state of victim after surgery. It could not be ruled out that some other cause unconnected with injury intervened by the police officers. The accused could not be convicted under section 302 or 304. His conviction was shifted to under section 326. So this is what's happening as per the section 300 subclause 3 of the Indian Penal Code. Okay, one by one changing, that's all. So depends upon police officer investigation and lawyers arguments. Okay, without arguments, without giving any citation, any evidence, will not prove. Okay, so we must give strong proof of fitness, then only win the case. Okay, today I am closing this session. We'll meet you again next video class. Okay, bye, thank you.